Go.
Hi everybody, it's July 7, 2023, and I'm outside the Hamilton courthouse. Not sure which courthouse a certain judge is at, but I am, as per the Ontario Small Claims Court Practice 2023, the practice is that, this is on page 720, the practice is that wherever possible, the motion for a new trial will be scheduled before the judge who presided over the original trial. Page 725. Note that Rule 1802 is an enabling provision which permits the admission of evidence. And this rule may be extended under 18021, may be extended or abridged under 3.02. Page 480, 3.02, powers of court. The court may lengthen or shorten any time prescribed by these rules or by an order on such terms as are just. So sometimes the law books like Martin's Criminal Code goes missing from the library. So I want to just show you one more before I go in, or a couple more. I'm answering the Honorable Mr. Justice A. Pazaratz, I hope I say that right, okay, in his ruling, where he asked a number of questions and pointed out a few things. Other judges have also concurred with his assessment, and I will just make note of public interest standing and or Rule 1704(5)(2). There is relevant evidence that was not available to the party, for example, the Honorable Alex Pazaratz and the public at the time of the original trial. And that was JN versus CG 2022 ONSC 1198 under Canley. And to address the Honorable Mr. Justice A. Pazaratz, line 67, why should we be so reluctant to take judicial notice that the government is always right? And he listed a number of things, you can look that up. 82, it would be helpful if, once and for all, the competing positions in science could be properly explored and tested in a public trial. Now, I just want to reiterate, I've worked in 4 Ontario hospitals, and I've spent months poring over the legal documents. And the most compelling, and it's funny how this has gone missing from my library for the last month or so, Martin's Criminal Code, page 769. Meaning of defrauds, generally. The classic definition of fraud is found in the judgment of Buckley J. in London and Globe Finance Corp. Limited. And to defraud is to deprive by deceit. It is by deceit to induce a man to act to his injury. For example, get the damn vaccine or any early treatment, since you're likely to live longer if you get or had COVID. The common cold, first imaged by June Amilda in 1964. It is therefore not a disease. A disease always progresses, may have relapses, shortens lifespan, or causes lasting harm. And other fraudulent means includes mere omission. Okay, mere omission. How many of you were told that Canadian data supported by Scotland and Netherlands shows you're likely to live longer if you had COVID? And I deem that failure to rule out bacterial or fungal co-infections, well, it's probably medical malpractice. But where through silence, an individual, okay, public health, whoever who has told you, media, whoever, hides from the other person a fundamental and essential information. So the silence or omission must be such that it would mislead a reasonable person. There's a case law there. Since the judiciary in many countries even believe the many lies such as safe and effective in regards to these injections, I believe a reasonable person would be misled. Okay, and I also want to note that flu shots somehow require ethnicity to be entered, and there are documented cases of flu shots and COVID vaccines being mixed up. So, I'm going to proceed and see how it goes. Thanks for listening.